Everybody, recording has just started. Good morning, everyone. We're going to give a couple of stragglers a few minutes to pull in, but we won't wait too long and we'll get started. I understand some great feedback concerning your session with Jill on recruitment the other day, so I hope you got a chance to participate in that. And I'm going to just ask anybody, maybe Andrea. It looks like you've got your mute off. Just make sure you can hear me okay before we get started.
Yep.
Perfect. Awesome. I fiddle around a lot with I do different kinds of presentations, and I've got these microphone settings and all kinds of things. I try to, when it comes to the ACSESS we're on for so long, really get rid of all the technology and try to keep it simple so we don't have glitches during the presentation. We're now going to get going. Got a couple more people rolling into the room, but I'm going to pull up our, no, what am I going to do? I'm going to share my screen. We'll click on share screen. And interesting. Hopefully everyone can see my screen. If there's anyone with their mute off, if you want to just let me know that that part of the presentation is working, that you can see my screen. Okay.
Yeah, you're good.
Yep. See it.
Perfect. And everyone can hear me okay. Yeah.
Yep. Yes.
Awesome. Okay, so today's presentation is probably for most of you your fourth session in your CPC certification. Today is on business practices and ethics. I'm going to repeat what I have in previous presentations. You're more than welcome to keep your video on or off. That's totally up to you. Please, during the presentation, keep your audio off unless you want to ask a question, then turn it on. That way we don't have to worry about feedback and the background noises and things happening and telephones ringing. But I encourage you, as always, I encourage you to, when we get to a part in the presentation where you want to make a comment, ask a question, get some clarification, tell me I'm wrong, turn your microphone off of mute and jump in. I don't monitor the waving hands that well when I'm here doing the presentation by myself, so it's just best that you jump in, and I trust that any questions you have will be worthwhile, so please, I encourage you to do that. Sometimes it just gives me validation that you're still there and not asleep, so always appreciated when you do that sort of thing. We've in our business practices and ethics session today, again, it's part of the CPC sessions where we have already done the legal aspects of staffing, legal aspects of recruitment, and I think many of you have also done the recruitment and selection section. There's still a couple more to go. And then later on in the year, you'll have an opportunity to also jump in on a new sales presentation that I'll be doing for you that's optional for you with your CPC. At the end of the year, or when you're completed your required training sessions, there will be a CPC exam. It's called the challenge exam. It's multiple guess. Again, I want to remind everyone that it's not important that you memorize specific wording or details. What is important, I give you the example when we were doing, for example, employment standards, you don't have to remember exactly how many hours in overtime or something like that, or what days are available. But you do need to understand the concepts and the principles that are included in each one of these so that you can make a good logical decision or know that that's something that you ought to look up and find out. And when it comes to a lot of these things, I also encourage people, once you know that it's an issue, even though I've taught these courses and written a lot of the content, as time goes on, I go back and take a look and say, hey, did they make some changes to human rights legislation? Have they added something? Are there new court cases? So it's really important that you stay up to date with this. And later on in the year, you're probably going to hear some notifications about how to keep your CPC up to date and have professional development courses on an annual basis. So those are new things coming. Our objectives today are to really review the ACSESS Code of Ethics and Standards. We'll be looking at some of the things that you can find on the ACSESS website. We're going to look at some case studies and some examples of the ACSESS Code of Ethics and Standards and some industry, legal, and professional ramifications of ethical and unethical behavior. And obviously, at each one of these things, we make a commitment to stay updated and to uphold the ACSESS Code of Ethics and Standards in our day-to-day business practices. In each one of these sessions, we review the ACSESS mission statement, which is really kind of relevant for today, because in today's presentation, we're going to be actually looking at the specific sections of the ACSESS Code of Ethics and Standards, and the mission statement really addresses some of those things. So first off, when we talk about ethics, you can take university courses in ethics, you can take philosophy courses in ethics, you can take business courses in ethics. There are ethics aspects to nursing, medical licenses, accounting. Everyone first starts off with the principle of the moral philosophy of ethics. And then as you move into your various aspects of your own business, then it starts to become critical that you start to break it down on what some of the issues are with respect to your own. But very often when we talk about ethics, we hear other words used to describe what we really mean. And what we mean is honesty and concern for others. Putting not only ourselves first, but our community first, and the concern for people. We think about integrity and fairness, accountability. Very often when we talk about ethics, we also get into the areas of management and leadership, and how managers and leaders conduct their businesses and themselves, and show examples and create culture in their organization. When we talk about ethics, we often are referring to a respectful manner in which the way we treat people and customers and the issues in our business. I've always said to people, when you're in sales calls and people say, what differentiates you from your competition? And very often there isn't a lot in many businesses that differ. We all have great software and great tools and great training, but very often the difference can be promise making and promise keeping. That we tell people what promises we're going to make to them, and then we actively pursue the keeping of those promises. Loyalty to your employer, loyalty to your friends, loyalty to your family. Being sometimes the most common denominator, the lowest common denominator is, well, I didn't break the law. So, this is what we hear often about in the ongoing sagas, for example, of Donald Trump in the United States. Is he an ethical person? Is he a truthful person, an honest person, a fair person? Does he treat people with respect? Does he have loyalty to those people that are loyal to him? Everyone's going to have a different opinion about where he stands on these things. But very often they take a look and say, yeah, but did he break the law? And so these things get dragged out for years and years and years because they're looking at the lowest common denominator, which is being lawful. I'm not sure, is being focused is ethical, staying focused on the commitments and the promises that you make, being truthful is ethical. At the end of the day, it's about doing the right thing and doing the right thing right. And there's a statement on the side of the page here: in 90% of ethical problems we face, we know what we should do. The real question of ethics is, are we willing to do the right thing? So knowing the right answer is important, or the right behaviors is important, but having the willingness and the commitment to do the right thing. And so, often I use the expression when we're describing some people, we say they have situational ethics, that, they're pretty good day to day and day in, day out until the challenge is their own personal challenge. And then the rubber meets the road. So first off, we're going to start off with the Code of Ethics and Standards for ACSESS, and we're going to look at 11 principles. Some of them are pretty straightforward and pretty obvious, so we won't necessarily spend a lot of time on each one of them, but we're going to try to use some examples of what we mean by these. And I'm just fiddling around with my screen so I can see some things here. So the first, there we go. So we've read this before. As members of the Association of the Canadian Search Employment Staffing Services Association, we commit to uphold this code of ethics and standards and to display it prominently in our place of business. We support the principles set forth below and acknowledge that compliance with the principles is in the best interest of ACSESS member companies, their candidates, employees, client organization, and the reputation of the industry as a whole in Canada. So this is the broad statement with respect to ACSESS Code of Ethics. And then, we asked the question, well, who's responsible for this ethical behavior? Is it our recruiter, customer, employee? I mean, this is rhetorical stuff, so we don't need to spend a lot of time on it. Sorry, I've just got this little menu thing that's popping in my screen, so which you can't see. I'm gonna move it around. And the reality is that we're all responsible for ethical behavior. Whether you're the recruiter or you're the customer or you're the candidate or you're an employee or an owner, we're all responsible for ethical behavior, everyone involved in the process. But as an ACSESS member and as a CPC recipient, it's really, upon us to kind of evaluate what's going on in our company with our coworkers, with our candidates, and with our customers. And are they adhering to an ethical standards that we feel proud of? And when we know those ethical standards, we can be consultants and advisors, and we can be setting a good example and kind of keeping the ethical peace, so to speak. So the first principle written in the ACSESS Code of Ethics is we will observe the highest principles of integrity, professionalism, and fair practice in dealing with clients, candidates, employees, and all of the regulatory authorities. And with respect to the confidentiality, and confidentiality is going to come up repeatedly throughout this process, of records in accordance with the law and good business practices. So this is the highest sort of overarching statement that will observe the highest principles. So what are some examples of good ethical practices, just so that we can start to think about what are we going to get at today? Well, maintaining promises of confidentiality, whether they're implied or specifically made promises, always seeking authority from our candidates or from our customers for authorization for disclosure of their information. And so what I mean by that is when you're recruiting for a customer, have they given you authorization specifically to tell people that you're recruiting for that bank or that insurance company or that call center or that oil company or, that hospital? Or are you supposed to be keeping their name confidential? Are you supposed to keep their name confidential up to a certain part in the process? Then you're authorized to disclose it. And the same goes with respect to our candidates. Once they've given you an application on their resume, have they specifically given you authorization to disclose their name to any potential customer or employer, or to only specific customers, employers? So knowing where you stand with respect to the authorizations for disclosure is very important. Knowing and complying with all legislation and regulations. We talked about that being the lowest standard you can possibly think of. Honoring contractual terms. And so doing what it says in the contract and adhering to the terms of the contract always is not only legally required, but it's an ethical behavior. We've talked in our previous sessions about equality, fairness, equity, respect, inclusion. Put the word inclusion in there. And so not only the things that you specifically say you're going to do in your agreements, but understanding the higher, all aspects of the law with respect to equality, fairness, equity, and respect, but also the highest principles and standards that sometimes go beyond the written law. Honesty and accuracy in your interactions. And sometimes I'm not going to say honesty is difficult. I think honesty is not very difficult at all. People might be in situations. I'm going to give you an example. In one of my companies just this week, we transitioned from one account manager to, the account got so big, to several account managers, and there was a breakdown in communication, and we had a requirement for a particular set of certifications that were required before a person could work in a particular role in that company. And they weren't necessarily standard certifications that were required by the entire industry, but that contract and that customer required certifications. And we had a breakdown in communication, started supplying some people that didn't possess those certifications. And the customer asked us, and our people answered honestly, and they cut us off. They said, "Hey, you're cut off." And they gave us a week to get our act together, and the team got together and they found the areas of the contract, and they figured out where we had a breakdown in communication and training. And they set up a contact with the highest level people and their day-to-day contacts with the customer. They owned it. They told them exactly where they screwed up. They told them exactly what we were going to do to make it better, to make it correct in the future. They apologized, but didn't try to downplay it in any way whatsoever. And the customer, just so you know, the customer said, "You know what? We just had a contract renewal and 3 suppliers. Every one of you guys screwed up. You're the 3rd company to have this kind of call. You're the only people that owned it. You're number 1 now on our list, and we're going to inform all of our people that you're number 1 because you were so open and transparent and honest about the mistakes you made, how you made them, and how you're going to fix them." And that's, part of our quality control process, but it's also part of the way that relationships work with respect to honesty and integrity. You can make mistakes. Mistakes aren't a breach of honesty or integrity. Covering up mistakes is. So what are some of the bad examples that we sometimes see in our industry? And they can include neglecting to perform reference checks, and even worse, falsifying or not disclosing negative reference checks when we hear about them. So not declaring an individual temporary or contract worker as an employee when they are in fact employees in the law. And we very often, companies do that so that they can not make the legal deductions and remittances of Canada Pension Plan, Employers Health Tax, in Manitoba, education tax, in Quebec, the taxe de santé and training taxes. I mean, there's all kinds of workers' compensation remittances, and then of course the deductions of people's income tax from their checks. And so people are often provided incentive to violate the law for financial reasons. The recruiter finds out that their client is hiring for a recruiter in-house and submits their resume for the role. I don't know that that's actually a ethical breach. It would be, people leave their jobs. People are unhappy in their workplace. People look out for themselves and they change jobs to improve their lot in life or to find a better role somewhere else. So I guess if a customer is hiring your agency to fill a job, the question is it ethical to your current employer to utilize your position in the company to serve them when you're really serving yourself first? So it could be an unethical behavior or a dishonest behavior. Lying to a customer regarding absences, latenesses, and et cetera. This is about a candidate. So if you find out about a candidate who's got a past of showing up late, missing days of work, not being punctual, having poor attendance records, do you just fail to disclose that to a new customer when you're doing a permanent placement? Or are you taking a risk with a person who's got a really bad track record and you place them on a contract or a temporary assignment, knowing darn well that they've got this bad track record? So those are judgment calls that you have to make. Contacting a candidate's former employer for a reference without permission or knowledge. I think we might talk about this later on in this presentation today, but, having specific approval of who you can do references with is really a great business practice. Having a person fill out a form that says that you have the right to do reference checks on anybody that they might have previously been employed with is not a good idea. You just don't know. Like, say, for example, a candidate is working in their current job. Are you going to, without their permission, contact their current employer and do a reference check and destroy their life and their relationship with their current employer, especially if you're not hiring them, they don't want the job that they're considering with you? Is it possible that maybe it was 2 jobs ago, but let's say, for example, 2 jobs ago, I had an employee and I gave them my blessing to go work with a friend of mine who owns another company. And then now, you call me looking for a reference. The first thing that I might do if I was unethical is I might phone up my buddy and say, hey, did you know that this person who's working for you is looking for another job? Watch out. Don't give them a raise. Don't treat them good. Fire them. Do something bad to them. Reprise against them because now they're not loyal to you. I mean, listen, doing reference checks with people without their specific permission is just loaded with all kinds of potential problems that you can't even foresee would happen. So here's an example of a question. Your customer is a pretty big customer. They spend $800,000 a year with you, but your margins annually contact you with a 4-month order. They indirectly hint that you restrict acceptable candidates on a discriminatory basis. So you got a really big customer, they're very important to you, and they tell you that they hint to you that they won't accept a male or won't accept a female or want a young person or won't accept a person of a particular race, creed, color, religion, place of origin, sexual orientation, marital status. And they suggest you they have some sort of bias. So, how do we handle that? And again, I think this, we've gone through this in our previous sections, but, do we take all the details and emphasize that you'll work hard to provide them the candidates possible? No, we're not going to accept a discriminatory order. Do we ensure you get the answer to the first question is you take all the details and you're going to work on it while adhering to non-discriminatory practices. That's the right answer. But I go beyond it and say, and we must inform the client that we cannot accept those discriminatory criteria. So of all of these answers, A is the best answer, but the better answer is we'll fill the job, but tell the customer we cannot adhere to discriminatory criteria, just to make it clear. And the other answers are that you get the request in writing to cover your butt, or you hand the assignment over to somebody else who will discriminate on their behalf. No, we don't do that. We go along with the discriminatory or not to We go along with the order. No, we don't do that. We inform the client that they will be obliged to use their company specific criteria after you've given them a short list of candidates. I don't really know what that means. I think that means, hey, you're going to be required to use your job description, but not use your preferences. I don't know if that's really worded that well. The correct answer to this question is we don't accept discriminatory job orders. When it is discriminatory, we inform the client the criteria that we can't adhere to. And to number E, we encourage the client to also not use those discriminatory criteria. Okay, principle number 2, we will provide leadership in the adherence to both the spirit and letter of applicable human rights, employment laws, and regulations. We'll treat all candidates employees without prejudice and will not accept an order from any client that is discriminatory in any way. So this goes to the point, the example I just gave you, and it goes to the point that I made earlier, that it's not just the letter of the law that we want to adhere to, but we need to ask ourselves, what is the reason for that law? What is the spirit and intent? And is it just a workaround to be discriminatory, or are we really upholding the principles of non-discriminatory recruitment? So we've reviewed this before in our previous session, so we'll go quickly, but age, creed, religion, disability, family, marital status, gender identity and gender expression, race and related grounds, so color, ancestry, place of origin, ethnic origin, citizenship, receipt of public assistance. We didn't talk about that before. Receipt of public assistance is usually covered in things like housing. So you can't discriminate against a person because they are receiving welfare or public assistance. If they can meet the credit check, they can meet the credit check. Their sex or sexual orientation, including gender identity and pregnancy status, sexual orientation. These are all areas, sometimes use different wording than what we saw in the actual legislation, but they all address the same principles and same things. So the client requests that we recruit millennials for a role of a designer, some kind of designer. The company is a startup and they request young, dynamic people to work with them because it's part of their culture. So, of course, implying that we have a young, vibrant culture, so therefore we must hire young people is wrong. Look at me. I'm old and vibrant. We need to talk to clients about what the criteria they're looking for. Are they looking for energetic? If they want people who have got high energy, who can multitask, learn new skills, then age has nothing to do with it. So in our second example, the client indirectly hints that the recruiter only presents female candidates for the front reception role. And again, we go back to the client and we say, what is it that you're trying to achieve here? I know that what we're looking for is a great customer service attitude. We're looking for people who are congenial and receptive and make people feel comfortable when they come into the office. We're looking for people that have the skills for Word and your telephone system and so on, or maybe to do this clerical work. So we re-emphasize that you're going to find the best candidate who possesses the skills and criteria for the job, and that gender got nothing to do with it. A client has a role for a forklift driver, and they must have their forklift license and be able to lift 15 pounds. So it's not a lot of weight. They request to have Brian back. That's okay. You can have a temp or a contractor who's worked there before and request that person back again. There's absolutely nothing discriminatory about requesting a person back again, regardless of their status and qualifications. If they like that person, they request them back again. But they say, but if Brian's not available, then we need to recruit another male person just like Brian for this role. And again, you know the answer to that question. Principle number 3, we'll take all reasonable steps to provide clients with accurate information on each candidate's employment qualifications and experience, and we will only present those candidates who have given us authorization to represent their application for employment. So this is about providing clients, it is what it is. We're going to be honest with the clients about everything that we know and have found out that we're allowed to disclose. And we're going to ask our candidates for permission to present their resume to that client. Now, by the way, I know companies that, for example, work on a VMS, a vendor management system, and they get dozens or hundreds of orders a day or week or month. And they have all these candidates over here, and all they do is they use their ATS to match a candidate's criteria to that, and they bombard the ATS or the government tender or something with resumes, thinking, wow, well, we got to move quickly, we got to be first, we got to get many, and they'll come back to us and tell us which candidates they think match, and then we'll find out if they're available or not. This is wrong. I mean, sometimes companies might actually find that throwing it at the wall in vast numbers is a way to make money. But in the long term, it blows up in your face. It doesn't treat candidates with respect. It doesn't respect their confidentiality. And so, sometimes being first, being fast, and being many isn't the right answer if it's at the expense of breaching the qualification criteria, the vetting criteria, and most importantly, the authorization for disclosure of private information. So this is an interesting case, and I always like talking about it because in this particular case, many years ago, I don't know who wrote this presentation, but it's interesting they put it in here because I was the expert who provided advice to and wrote expert reports for the legal case. So I happen to have some inside information about what went on in this case. And, so this is a case where a placement agency suggested the employment of a candidate to a company. And it was a permanent placement with a fee associated to it. And they were doing it without checking the employee's references. The company hired the employee, and she went on to work with the company for 2 years before resigning. She resigned in a bit of a kerfuffle because there were some allegations of theft taking place. After the employee resigned, the company became aware of the facts that the employee had, in fact, been defrauding them. And the company sued the employee, and they obtained a civil judgment against her. So they proved in court that she stole from them, and they got the courts to, I think, garnish her wages in her new job and her bank accounts to get some of that money back again. But they didn't get it all back, and they didn't get most of it back. Additionally, the company sued the employment agency for negligence on the basis that the employment agency did not conduct references or a background check on the employee. So here's some of the issues that came up in this case. First off, there was no signed agreement between the agency and Leather Treaty. By the way, Leather Treaty treats leather. They make leather they process leather so that people can make furniture and clothing out of it. So there was no signed services agreement between Leather Treaty and the agency. There was an intermediary consultant. Leather Treaty had hired a HR consultant to work on their behalf, and the HR consultant actually contacted the agency and negotiated verbally the terms of the agreement. And in doing that, the consultant suggested that because they were a consultant in human resources, that they would probably feel better if they did the reference checks themselves. In other words, this consultant thought that they could do a better job, or maybe didn't trust the agency to do their references, but that was kind of left vague. They didn't discuss, and there seemed to be some confusion, especially when they got to court, the differences between what reference checks means and background checks means. So the client and the client's consultant were using the terms background checks and reference checks interchangeably in their statement of claim. And they didn't think of reference checks as actually calling previous employers and ask them what their performance was like and validating the dates that they worked there and their pay and so on and so forth, and asking if they were rehirable and so on. And by the way, it turned out that this particular employee, if you dug deep enough, you might have been able to find out that there were some previous problems with previous employers. And they didn't differentiate those between background checks, which often include credit checks, the validation of the dates that they worked, their education that they claim to have on their resume, and police criminal checks. So background checks is a generic term that talks about the validation of information, credibility of information, and including credit and criminal background checks. And reference checks often refers to specifically the relationship and the performance of an individual in their prior employment. There was some arguments at the court case about what the industry norms were, about what leather treaty ought to have expected to occur in the process, and what the agency should have been doing because they were industry norms. So we talked about, common law. So very often common law will go to industry norms and say, if you don't have a written contract, you still have a contract. So what are the expectations in the industry norms and standards? And if everybody always does it this way, then the only way that you could maybe not always do it that way in this contract is if you specifically exclude those or change the terms in writing or verbally or somehow. The company, meaning the agency's website, contained some promises about background checks and reference checks, implying that they always do it, even though there was no sharing of brochures or specifically the website itself. It was in the public domain that the company does this stuff. There were a lack of checks and balances in the company, the client company themselves. I mean, they hired this person and gave them a whole ton of authority and responsibility with respect to accounts payables and access to bank accounts and accounting records for balancing records. And so the person wrote themselves checks a lot, whether it was false expense reimbursements or whether they wrote them to a company name that was similar to a company that they operated and falsified invoices. There was a whole web of dishonesty taking place on how this person wrote checks and got money out of the company and put it through the accounting system. The client's lacks of checks and balances provided some blame on the company to mitigate the damages. And so there was also some calculations of the damages, which of them were legitimate expenses, which of them were the company's negligence, which of them did they already get paid back, or were they going to get paid back because they had the civil suit against the employee. So these were all issues that found their way into the court case. So at the end of the day, in this particular case, the agency did do references, but they did references after the person was hired. So the person went in for interviews with the consultant and then with the owners and managers of the company. They offered the person a employment right away. The agency felt like, hey, we haven't done references here. So they made an effort to do references. They were took a long time to get them. They did get some callbacks. They did get some information. They didn't receive anything in those reference checks that would have suggested that the person shouldn't be hired. If they were done prior to the offer of employment, the customer might have said, hey, those are pretty vague references. Why don't we dig a little deeper and see if we can get more? But there was nothing there that would have suggested they shouldn't hire them. The consultant didn't do reference checks, although they suggested the consultant, who was an independent consultant, didn't do reference checks when they suggested they probably would. There was no written agreement. There was no reason whatsoever that this person shouldn't get hired, other than the fact that the boxes weren't checked. And, they were able to determine that reference checks were, a pretty standard procedure in permanent placements, but background checks for credit checks and for criminal background checks were not standard, and that those are often delineated specifically in the agreements. And although the client won the case, they won nothing, because it was impossible, based upon the negligence that the company showed in their operation of their own company. Otherwise, in other words, the checks and balances and procedures they had in their company, that the agency held some responsibility, but not whole in responsibility. And when you actually calculated the damages, they were safe enough to argue that if the company had operated themselves in a normal way with checks and balances, that they would have been able to catch it really early, that they wouldn't have probably offered employment to the person without the reference checks. And so the calculation of the damages didn't even cover the costs of the case. So this is an example of a lot of mistakes and a company not violating their ethical standards, but not doing a whole bunch to keep implied industry standard promises, and probably should have set a higher standard for themselves. So it's a ethical conundrum because they weren't specifically dishonest. Examples of what not to do. I love these. Sometimes when we talk about ethics, we put more emphasis on what not to do than what to do. So, what not to? Let's not make up references or ignore unfavorable references. And let's not alter or fail to disclose those unfavorable references, tests, or test scores that we might receive about a candidate. Not seeking out approval from a candidate to submit their resume, so that authorization, that's a bad thing. Falsifying background screening. So if you find out something about a person's skill level, or even candidate preferences, if you find out that a candidate doesn't want to work that far from home or wants more money, not disclosing that information to a client probably is just a recipe for fall off and credit replacements and disasters. And then some argument later on about whether or not the guarantee is expired or not, and it just kind of gets ugly. Principle number 4, we will supply candidates and employees with complete and accurate information as provided by the client regarding the terms of employment job description. So the clients give us these job descriptions, and in the best case scenario, we've got an agreement, and along with the agreement, we've got a written job description, and even had a consultation with the client to ask for more and further detail about who they report to and what the work style is like and what the culture is like, and what the benefits are like, and all of that kind of stuff. So collecting complete and accurate information is the first step, and then disclosing that complete and accurate information to the candidate is the next and most important step. There's a nice little phrase on the side of our screen there that says, accuracy is the twin brother of honesty. And so inaccuracy is the twin brother of dishonesty. Case number 2, we place an employee with our client as this is an interesting one, as a data entry operator. Let's assume this is a temporary assignment. But it doesn't matter, it could be permanent, but let's assume it's a temporary assignment. We place an employee with our client as a data entry operator. When we contact the employee a few weeks later, we find out that the employee, that they are not only doing data entry, they're also using Microsoft Project, to track milestones for their manager, and they're working in Excel, and they're creating pivot tables, and they're running analysis reports weekly on charts. So they're using a far greater skill level in their job than was in the original job description. So do we have an ethical conundrum here? And I don't know that we do. I know this, that In Ontario, it's written into the law in the Employment Standards Act. We discussed this. And in other provinces, it's implied in the law that as a temporary help agency, we are required to provide certain information about assignments when offering the work with a client. We have to provide specific information to the temporary worker, like the legal name of the client, the contact information of the client, including their address, phone number, and so on. But also if the client has other business names, if they're the implication is there that we might be misleading somebody by not telling them, that they do something under a different business name. We got to tell them the hours of work, and here a general description of the work. Now, I don't know what the legal issue would be if the client gave you a general description of the work and it was pretty accurate in the client's mind, and you provided that exact same information to the candidate, and the candidate accepted it. And when they got there, the client wished that they had somebody who could do some more higher level work, and the candidate exposed their skills and qualifications so that they're capable of doing higher level work. And between the two of them, they ended up modifying and morphing the job description. On the face of it, that doesn't present a legal problem or an ethical problem whatsoever. Your ethical problem arises when, say, for example, you have very specific and written pay rates that go along with each job description, and now you've got a person performing a different job and not falling into your very specific written classified pay rate. It becomes an ethical problem when the client clearly has a pay rate for that job, and they're having that person do 100% of that job, and they're falsifying, the description of the job in order to pay a lower rate. We run into an ethical problem if we've got, say, for example, all kinds of men doing that job, doing the reports and the Excel pivot tables, and this female or this person of color or this person of age difference is clearly in an area of prohibited grounds, and that it would appear as though that they're getting paid less because of that area of prohibited grounds, that they're getting paid less because they're a woman, for example. So we have no ethical problem if it's just one client, one temp, one office, they figure out things, the temp offers added value. That itself is not an ethical problem. But there's all kinds of potential hidden ethical problems that could exist in this particular scenario. Principle number 5, we will not recruit, encourage, or entice a candidate whom we have previously placed to leave the employ of our client, nor will we encourage or coerce an individual to leave any temporary assignment before the stated completion date. The first part of this statement is pretty straightforward. We often have anti-rating clauses. We've got clauses in our contracts with our customers, particularly when we're providing permanent placement and search services, that we will not recruit the candidate back out of that job and place them somewhere else and get multiple fees from different customers for the same candidate. I mean, our whole point in the services that we're providing is to help customers fill their job vacancies, to help them maintain a stable and predictable workforce. And by providing good temp and contract people who don't turn over or qualified for the job and stay in their jobs and are committed to their jobs, and by placing people into permanent jobs through search services or placement services, and that we know that they intend to remain there, is the whole objective of the service that we provide. And so recruiting those people, again, would in most cases not only be a violation of the principles of the services that we provide, but I'm pretty sure most contracts, especially if they're written by the client, would be a violation of the terms of the agreement. The second part of it becomes a little bit more questionable. So, because we start to get into these strange scenarios where temporary workers go into an assignment and they're there for a period of time and they want to upgrade their lot in life by applying for other jobs or finding other assignments that pay more money or have more hours or closer to home. And, very often people use temporary assignments as a stepping stone towards the job that they really have set out as their overall objectives. So under what circumstance would we entice a candidate or employee who has been previously placed at your client's site to take another role you're working on? The answer is under no circumstances is it acceptable. Now we've got this question of honesty. We've got a moral dilemma when we've got some of these other scenarios. You place a person into a job, you charge a customer a fee, the person's working there for 2 months, then they see a job posting that you have on your web company website or, online or someplace, and they call you up and say, hey, Mr. Consultant, you placed me in this job with your client 2 months ago, and I see that you've got a better job. I'd like to apply for that job. And you say, geez, I can't represent you in that job. We've got an obligation over here. And they say, well, I'm going to quit anyways. I don't like this job. It's terrible. So now you've got this knowledge about a person that you placed into the job. They're going to quit. To what degree do you have an obligation to the person for disclosing confidential information to you? To what degree do you have an obligation to your customer because you guaranteed that employment? You start to get into these moral conundrums where you got to ask yourself, how do I behave in this circumstance? And I'm not going to tell you how to behave. I'm just going to say you've got a moral conundrum. You've been given confidential information from a candidate that you're not authorized to disclose, and you've got an obligation to your customer to keep that job, to put the best person in that job and to guarantee that job. And all I can say is behind you, in your case, maybe you ought to start recruiting somebody as a backup because you might be getting a call from your client pretty soon. But don't make it a call because you placed that person somewhere else and created even a worse ethical situation that you need to be in. So, playing nice in the sandbox, people playing together with common goals and objectives with their clients, their candidates, and the agency often results in the right answer that you need to find. So a recruiter needs to fill another role very quickly, but the margin is higher in this other role. An recruiter wants to pull out an employee from a national account where the profit margin is very low. So you're in the temporary or contract business and you've got a national account. In order to win that account, you cut your margins pretty substantially and you place this person into a job. But then along comes a new customer who's willing to pay several dollars an hour more. You can get a higher margin, pay the candidate more. Would you pull that person out of that assignment? The Code of Ethics and Standards says that you will not entice or coerce an individual to leave their assignment before its completion. So the answer is no, you can't consider that candidate for that job. You just can't do it. Now, if the candidate quits the job and comes to you and says, hey, that job is terrible, I quit. If the candidate comes to you and says, hey, I saw you've got a posting for a job, I'd like to apply for that job, you can ask the candidate, you can say, in order for me to do that, I need to disclose to the customer that you would like to come out of that job and be placed somewhere else. And I need to give the customer the heads up on this. And I need to give them the authority to give me a timeline, or they have the right to say no. And I can't represent you if they say no. So you either say, no, I can't do this, and you don't, or you have this very, very open conversation and you don't violate your obligation to the customer, depending upon how they react and respond to you. And only you will know your relationship with the customer and what's in the best interest of the customer. But you cannot, in accordance with the obligations under the Code of Ethics and Standards, entice or coerce that person to leave their job early. The employee tells you they have another opportunity and they want to leave the assignment. So now you've got an employee who's on an assignment for you and they want to go work for somebody else. Well, all's fair in love and war and competition. You can now engage in counter offers and all kinds of things because you're not enticing the person to leave another job early. You're enticing the person to stay in their job until completion. So understanding the differences between enticing a person out of a contract that they've made a commitment to and enticing a person to stay in a contract they've committed to are two entirely different things. The recruiter locates a candidate who is currently working for a competitor on a 3-month assignment. They would be perfect for the job order that you're working on, and you could even pay the person more money per hour. So here's the moral challenge. The Code of Ethics and Standards says that you will not, let's just go back a couple screens if I can do that. We will not restrict the right of a candidate. Nope, sorry, I'm in the wrong place. Okay, so if we go back to principle number 5, come on, principle number 5. The second part of that says, nor will we encourage or coerce an individual to leave any temporary assignment before the stated completion date. So that means the assignments that you have and the assignments that you know that they're on with your competitor. So it's a 3-month assignment. And phoning up the person and enticing them to leave it 2 or 3 or 4 weeks early would not bode well on your competitor. It would not look, you would be encouraging a person to breach. It's one thing if you say, hey, look, I'll take a job forever, and you work there for 2 years, and then you decide it's time for me to upgrade, and your company can't provide you with an upgrade. But you make a 3-month assignment and you work there for 2 months and there's 1 more month to go, and you say, I'm going to leave now a month early because I can make $1.50 or $3 an hour over there. It's in my best interest. Then that is a breach of a promise. So, and it's not a big thing. Like, you made a promise to stay for 3 months. It's not for the rest of your life. It's not your firstborn child. It's for 3 months. And so coercing a person to breach their promise would, according to principle number 5, be a violation of the Code of Ethics and Standards. Keep this in mind. This is different from a person who's on an assignment for 3 months, 6 months, 2 years with a competitor, and they're not happy with their lot in life. And it's time for them to make that stepping stone. They can't get it through their current agency. They contact and apply to you, and they say, yeah, I got to give them 2 weeks notice. And you honor the respect, the fact that everybody leaves jobs and they give an appropriate amount of notice. That's different than you contacting someone and encouraging and enticing them to leave their job early. So hopefully I was clear on that one. Okay, principle number 6. We will not restrict the right of a candidate or employee to accept employment of their choice. Freedom. So Mel Gibson said us it all. Freedom. The whole intent of this very vague statement is that if you've got some examples, if you've got a person working on a temporary assignment, contract assignment, and the customer approaches them and said, hey, we want to hire you, you will not and should not call up the person and say, hey, you can't do that. You're our candidate. You have to go through us. You would have liked them to go through you. You would have asked them to be open and honest to you. But the fact of the matter is, employees, so long as they're not violating confidentiality agreements or copyrights or patent agreements, fiduciary duty agreements, it's even illegal in Ontario now to have non-competition agreements. So if you consider this to be competition, they're going into competition with you because they're taking your assignment away from you and getting the money themselves. We're not supposed to restrict them from doing that. Now, That doesn't mean that you don't have an agreement. You will probably, hopefully, you have an agreement with your client that says that within the first number of months, in Ontario, the law is 6 months, you can only charge a fee to convert a temporary worker to a permanent job within the first 6 months of employment. After that, you got to let it go. You can't charge a fee. So if you've got an agreement with your client that says if they hire them within the first 6 months, there's some sort of calculation of fee, that's between you and your client. It's not between you and your candidate. So calling the candidate and make them feel guilty or threatening them with something, or, firing them, or saying, I'm going to interfere and call the customer and tell them how bad you are. This is a reprisal. It's against the law. It's unethical. You have to allow people to make the choice as to who their employer is, which doesn't mean you can't enforce agreements. So if you get an agreement with the customer that says they'll pay you a fee, then you go to the client and you collect your fee. And if you've got an agreement with the candidate that they're not allowed to disclose confidential or use confidential information, if the reason they're there is because they have confidential information and they're going to breach some agreement, then fine. But we can't just stand in their way of getting employment. The same thing goes with respect to, we're going to talk about multiple representations. Two agencies submit the same candidate to the same company, and you somehow and the other agency wants to collect.
Hi, Steve.
Hi guys, I think we.
Okay, I have a question. Should I wait?
Yes.
Okay, back to the principle number 6. I just want to understand. So can we not sign, are we talking about non-solicitation? Can we sign that with the candidates we send to clients or not?
No, I think you would have a really, really hard time having a contract that said, that they won't solicit your customer, and then your customer offers them a job and you try to go to court to call that solicitation. Solicitation is selling of a product or service. So, if they're there on an assignment, first off, in Ontario, to use it as an example, because the same principles will exist in other provinces in common law. It's just that Ontario, they chose to write it right into the employment standards legislation. But the same principles will exist in common law. So I don't mean to overemphasize Ontario. Ontario isn't the center of the universe. But when something's written into a statute, it's pretty clear what the statute is intended to mean. And very often that statute is written because it's reflecting common law, the norms of law. So in Ontario, it's against the law to charge a fee for a candidate 6 months after the first date that you introduced them to a client for temporary help. So it doesn't matter how many hours they work there, weeks they work there. If you introduced them as a temp 6 months ago, whether they worked there one day or the entire 6 months, after 6 months have gone by, you can't. If you've got an agreement with the client that says that if they hire one of the people that you referred to them through temporary work within the 6 months, and you've got a fee calculation, that's contractual law. But if you tried to say, hey, look, we introduced you to a client, you're working there, the client approached you for a job, or you just applied because the job was available in the public domain, they post their jobs and you applied for it, and you call it solicitation, you'd have a really hard time with it. And even if you did, I don't think you're going to get, if you're going after the employee, you're not going to get the sympathy of a court, because people have the freedom of choice to choose who their employer will be when the offers are on the table. So your beef is with the customer, it's not with the worker.
Okay.
Does that make sense?
Yeah. Okay.
Yeah. Now I'm going to, there's always an exception. We have had independent contractor relationships with professional IT, engineering, and accounting people. And it is easier and well within the law. As a matter of fact, it's sort of substantiated in employer health tax decisions, again, in Ontario, because it's been, but in other provinces too. And workers' compensation often treats an independent contractor as an independent contractor. So, there's all kinds of rules about how to define an independent contractor. So now you've got, say, for example, an IT professional who owns a company, whether it's a sole proprietorship or incorporated, and they invoice you for services. And you've got a non-solicitation agreement with that company. And that IT professional solicits the customer to get the business directly from the client. Now you've got something you can stand on. Because you had a legitimate non-employee relationship and a written contract for services that had a non-solicitation, non-competition clause in it. And they solicited the business on their own for their own company. That, my friend, is enforceable, because that does not have to do with employer-employee relationships. That's got to do with business agreements.
Yeah.
They are enforceable. Does that make sense?
Yes, Steve. Yeah.
Okay.
Thank you.
You're welcome. Okay. Principle number 7. Oh, by the way, we always are going to take our break at 2:30 for 15 minutes and then come back at 2:45. So we've got about another 20 more minutes to go before our break. So principle number 7, we will not misuse membership privileges in ACSESS for the purposes of recruiting other members' staff or in any way that may otherwise injure our candidates, employees, or competitors. So we've got a situation here. We've got a situation here where the agency you work for has just experienced big turnover. You got lots of openings inside your company. And ACSESS has an association meeting that's coming up in your chapter locally. So you plan to attend the meeting so you can tell everybody there, hey, by the way, my company's better than yours, and we've got all kinds of job openings, and we would love to recruit you and hire you. Why don't you come and apply for a job in our company? Well, this would be an unacceptable method of recruitment, because we are paying our membership dues so that we can participate with the association in upholding and enhancing the reputation of the industry, and that we would not use confidential information or relationships that came to us in a business partnership to cause harm to the other partner in the relationship that is unfair and unintended. So we don't sign an agreement to uphold the code of ethics and standards and pay a little bit of money, and everybody else pays a little money, and we all go to the same meeting so that we can become better professionals, and then use that relationship and the confidential information we get access to, which is the names of the people who work for our competitors, and violate their trust in us to benefit ourselves. So when you go to an ACSESS meeting, you leave your guns at the door. We're there to better all of us, not to share confidential information, not to collude, not to participate in unfair competition, and also to not use the guns at the door to sneak your gun into the room, into the saloon. So we don't use our membership in any way to try to create our benefit for ourselves if it is at the expense of another member company. Principle number 8, we will derive income only from clients and make no direct or indirect charges to candidates or employees unless specified by a license. Now, we've got the unless specified by a license here because it's possible that you can be, say, for example, a certified immigration consultant and a member of the immigration association and covered under the College of Immigration Consultants, or you could be a lawyer who provides immigration advice and also operates in an employment agency. So you might be licensed to do something to charge fees to a person, but as an ACSESS member, we say, don't do it. If you're a lawyer and an employment agency, create two corporations. If you're an immigration consultant and an employment agency, create two corporations. And if you're legally charging consulting fees to people to how to immigrate to Canada and handling their application process, don't have anything to do with the fact that you found them a job. Because immigration consultants are not allowed to charge people based upon contingent upon them getting a job. It's illegal to charge people fees to find a job. You can charge, an immigration consultant could charge a person fees to give them advice on how to qualify to immigrate, on how to fill out their forms, on to manage and monitor the submission of their forms, but they can't charge a fee that is contingent upon them getting a job. And so we talked about this earlier, that it's against the law in Ontario, because the Ontario decided they were going to codify a principle in our Code of Ethics and Standards, and a principle that is upheld in every other province and common law in Canada, that we do not charge fees to candidates. So our income comes from our clients, and it does not come from our candidate inventory. Principle number 9. We will maintain the highest standards of integrity in all forms of advertising, communications, and solicitations, and we will conduct our business in a manner designed to enhance the operational image and reputation of the employment, recruitment, staffing industry. Now, I'm going to tell you that up until today, this presentation, for some bizarre reason, had an overemphasis on when it's emphasis, it's on the wrong syllable. And so it had an overemphasis on some of the wrong principles. And it really talked about, like, grammar and spelling and accuracy in advertising. But, I really think that we need to talk about our honesty in advertising. And so what I mean by that is we want to keep our posts up to date. If we've got posts out there in the interweb that are 6 months old, implying that we've got this job available today, keep them up to date. Make sure your posts are accurate and they reflect the terms of employment and the skills that are required in the jobs that we have available right now. Our only post open jobs, and I put there unless specified. It's okay to say, my company is always recruiting for a variety of companies that are hiring, Java application developers. And, last year our company filled 75 Java application developer jobs, and we expect to fill 75 more with a myriad of companies in variety of industries. Apply with us and we'll help to match you up with one of those companies. That's okay. That's marketing advertising. It's not job specific advertising. But if you're going to imply that it's a specific job, make sure you have a specific job. If you're going to put pay rates into a job, make sure they're accurate. Don't overemphasize them and tell people that they're. I remember when I started, I'm old. When I started in this industry, there was a company in Toronto that was always recruiting for administrative assistants and customer service representatives and front office staff, receptionists, and so on. And they constantly ran ads saying that they were recruiting for airline, back in the day, they called them stewardesses and stewards, because they felt that people, in a really bizarre sort of discriminatory way, that the type of profile of a person who would get hired by an airline to provide onboard service would probably do a great job in customer service with my customers. And there aren't that many airline jobs, but everybody wants one. So they lied all the time. And it was wrong. And that company went out of business eventually. So, make sure that we actually reflect the job descriptions and the pay rates. So telling people that they pay $30 an hour when you could only offer them 15 or 25 is not right. Be careful with unintended or implied violations of human rights. I honestly I believe that most people, when they're writing ads, if they were accused of violating human rights by being discriminatory in their posting, they would probably come back and say, that's not discriminatory, because they really didn't get the implications of the recent graduate typically means young people. Vibrant personalities very often can mean, young people. So be careful about the unintended or implied meaning that could be conceived to be a violation of human rights. Are you required to protect your client's identity? Did they give you specific authorization to put their name in the ad? It's interesting. We had one company in Montreal that got a job order from their customer, and the job order's customer and their written job description were almost exactly the same on paper internally as it was online. So the company literally cut and paste the job description, and anybody who knew how to do job searches could find out pretty quickly who that job was with. And the customer accused them of violating their confidentiality by cutting and pasting the job description, which basically was telling everybody exactly who the job was with. So be careful about protecting your client's identity, not only specifically, but in implied ways. Protect your candidate's privacy. So once you receive information from people applying online in your advertising or any other place, once you've received the application, that doesn't necessarily give you carte blanche to disclose that information to anybody and everybody for any reason that you see fit. Do you acknowledge your applications with integrity, saying, hey, we just want you to know, we got it. We're going to talk to you. We're not going to talk to you. We might talk to you. If we talk to you, this is the way we're going to talk to you. This is the other information we need. Acknowledge your applications, because failing to acknowledge it, sometimes nothing implies things that lack integrity. Pay it and fail to uphold an implied promise. Pay attention to, this is interesting. This is why we have all these job boards and ATSs and applicant tracking systems and other things over here on the right as examples. Very often we can put a job posting into Bullhorn or into Career Builder or into our internal system, and that it'll wrap and go out to our website, and it'll go automatically and be posted to other websites. Take a look at how that wrapping works. Do the fields match up? Do the field names match? Do they update properly? When you cancel a job on your company website or internally in your applicant tracking system, does it cancel it out there on the internet? Does it cancel it on your website? Does it, when it posts the job, does it actually, post some things that it's not supposed to post? And, I'll tell you what, I could probably go out to 100 staffing companies right now and take a look at an internal posting and ask the people internally, do you know what that looks like by the time it makes its way to Job Boom or to Monster or to jobs.ca, Glassdoor, or Career Builder or ZipRecruiter or Indeed? And they have no idea. They've never looked at it. They've never seen it. Pay attention to how they end up wrapping. Now, this is the thing, the type of example. This affects your professionalism and reflects upon the industry's professionalism. And when you reflect negatively upon the industry's professionalism, you also put our integrity honesty and ethical behavior into question. When you're just so sloppy, you're probably sloppy with everything. So, do some proofreading. Let's talk about social media a little bit before we go and take our break. Listen, we could run and probably will run entire and have run at conferences before and chapter meetings, entire hours and days on social media. But let's just take a look at some of the really higher principles of social media, particularly for you as a consultant or recruiter or sales representative or internal manager working in the recruitment and staffing industry. Be mindful that whatever you post, whether it's in your own social media account or whether it's something that wraps up to the internet, or whether it's on a company, Facebook page or LinkedIn page or in a group, be mindful that even if you think you've edited it and deleted it, it's the internet. It's there forever. There are entire services that you can go to for free that says, and you can ask them, what did that web page look like on December the 11th, 2011? And if that page existed, they've got a historical record of what was there. Know that people take screen captures and download and copy and paste and forward things and repost things. It's all there. Remember, once you post something, it lives on forever. So be respectful. Be respectful to other people, to other companies, to competitors, to your employer, to your coworker, to your customers, to your candidates. Be respectful, be truthful. And remember, once you post it on the internet, it's available to the world. So honor every participant's right to privacy. You can express your own opinions, but when you express your own opinions, do you just declare that these views are expressed, that they're yours and yours alone, and that they don't necessarily reflect the views of your employer or of the website that you're posting it on? So be careful, because people don't get that. But guess what? People don't read disclaimers. So when you're posting out there, even if you're posting on your own social media account, be careful on how it reflects upon you as a professional. Do not disclose confidential information, proprietary information, commercially sensitive information. And remember, they're all integrated. What shows up on, Insta is going to show up on Facebook. What you post on, Twitter is probably going to find its way on every other social media site going, on Pinterest, on Google+. Be careful about how these things work. If you're a manager or an owner of a company, have a policy. Have a policy that talks about what you're allowed to do and not allowed to do on social media while you're working inside the company and on company equipment. If you're working from home, what you're allowed to do and not allowed to do. Keep in mind that you've got way more control when you provide the equipment. And also keep in mind that because of the nature of our work, we want all of our jobs blasted all over social media. If the jobs are written accurately and they're timely and they're honest and they reflect the same job descriptions and they're up to date, we want them posted on, we want them posted on every form of social media to enhance your application blanket that you cover. So everything that you do in the recruitment and staffing industry ought to be declared to have something to do with your ability to recruit. When you get a following of connections on LinkedIn, are those followings there because you as a gardener are connected to every IT professional in Canada? Or are you connected to every IT professional in Canada, to hundreds of thousands or millions of IT professionals because of something to do with your work? It's implied our social media connections in our industry are to serve our industry. And so if you've got two personas, I strongly recommend that maybe your private persona be totally private. Something else, use a different name. I've got a daughter who's a teacher who likes to post pictures of kids and charities and family on internet. So on the internet, she doesn't go by her last name because in her professional career, she posts using her full name to parents online, using all kinds of things that have to do with homework and what the classes are doing and school trips. And she uses all kinds of platforms to try to make those things available to the parents. So try to figure out how you can respect confidentiality and also promote your business at the same time. Ensure that you conduct yourself outside the workplace in a way that would be acceptable within the workplace. Principle number 10, as we move towards the last couple minutes, 3 minutes before we take a break, we will recognize and respect the rights and privileges of competitors in a true fashion of individual initiative and free enterprise. And we will refrain from engaging in facts as unfair competition. So remember that we have laws in Canada called the Competition Act, and it has to deal with discussing prices with our competitors and terms of business for our competitors during a bid process. This price fixing is illegal and it's unethical. Our customers don't want us to do it. It's not good for your candidates because you're not getting the highest prices and wages that you could for them. It's unethical and it's illegal. And it's a violation of the terms of probably every contract that you ever bid on. Recruiting from a competitor for access to confidential information. You can recruit from wherever you want to recruit from, so long as you're not violating the terms of your access agreement by using your membership and you're not using confidential information that was given to you for a purpose of which it was not intended. Tortious interference or a workforce transfer. We're going to talk about that later on, but that's where you're winning or losing a contract that is legally following a process to change from one supplier to the other, and you use a relationship as either the incoming supplier or the outgoing supplier to violate the terms of that agreement and interfere with the other competitors. Knowingly multiple submit a candidate. So you know that a candidate comes, he says, yeah, I applied for a job at ABC company, XYZ employment agency submitted my resume yesterday. And so you just go ahead and say, I got that job order. I'm going to submit the same candidate and fight for the right to represent them. No, knowingly multiply submitting a candidate to the same job is a violation of your duty to that candidate, to your customer, and to the other company. It is unfair competition. Adhering to legislative requirements and contract terms. So what this means is if you've got a whole bunch of temporary workers and you need to be paying workers' compensation, but you don't declare them as employees and you don't remit your payments, you're undercutting your competition by breaking the law on your expenses. That is unfair competition. And I don't think it exists anywhere in Canada with respect to abusive market dominance, but it is in the law in the Competitions Act in Canada that if you have market dominance, you dominate 30, 40, 50% of the marketplace, that you set prices and dominate some of the rules on which things have to be done. We hear about market dominance all the time. And this is why the Competitions Bureau takes a look at mergers and acquisitions when two companies go together to determine whether one airline can purchase another or whether one pharmaceutical company can purchase another, because they might have market dominance and create unfair circumstances. Okay, this is a silly question, but it's a good one, and then we'll move on. But you have a candidate who walks in to your office, they're applying for a job, you go out to the lobby, you speak to them, and you realize that this particular candidate doesn't really have the qualifications or skills for the kinds of jobs that you're currently recruiting for or that you generally recruit for. And the question is, what do you do with this candidate? And the answer is, you're allowed to give advice so long as it's honest and advice and it's meant to give them, a step up in the world. You can say to them, hey, look, we don't usually recruit for that job. You're welcome to look at our websites from time to time because, we have different jobs that come up. So by all means, monitor our website and look at it all the time and call me if you see something that's of interest to you. But meanwhile, this particular job board seems to specialize in your skill, or this particular employment agency who works downstairs or across the road, they specialize in that. They specialize in licensed fork truck drivers. I think that's all they do, or truck drivers or something. Why don't you, head up over there and ask for Mary? It's okay to do a favor to people. That's not a violation to your, if it isn't intended to cause your company harm and it's to the benefit of other people, you can do nice things. Nice things don't have to be illegal or inappropriate. If it's in competition with your company or whatever, then you might want to try to keep that candidate all to yourself. By all means, you go ahead and do that. And our last principle before we take a break, we will ensure that all of our clients, candidates, and employees are aware of our duty to abide by the Code of Ethics and Standards and such supporting policies and guidelines as may from time to time be adopted by the association, and we will undertake to bring any potential infringement before the appropriate bodies. And so what this really means is that we've got a customer or a competitor who are violating the law, doing something inappropriate, doing things that are unethical. We have a process at ACSESS to file a complaint. And just so you know, it goes like this. If you file a complaint with through the ACSESS complaint process, can do it verbally to start off with, and it's very likely that someone in the ACSESS office will intervene, if you want them to, will intervene with the company and say, hey, we've got an unofficial complaint that there's questions on your application form that are in violation of human rights. Or we've got a complaint that you're, not paying employer's health tax. And we just want to let you know that anybody who employs people through an employment agency, a staffing company in Ontario, you're required to pay employer's health tax on your employees. And usually the problems are resolved. But if it's not resolved and you want to escalate it, you have to put it in writing. That in writing goes to a confidential committee of staff, and the executive director or an appointed person in the staff will attempt to address it unofficially. If the member company or company do not comply, then it can be escalated to a not a standing committee, to a special committee from the national board, who will then put together a committee of 3 or more, and they retain confidentiality and they attempt to resolve the problem. And then if it escalates to a further level and they're found to be non-compliant, found to be not respectful of the Code of Ethics, found to be violating the law, then the referrals will go to the appropriate legal authorities and a person will be expelled or suspended from their membership. But everyone is given the right to make a complaint and for there to be a peaceful and fair and appropriate resolution, and then for there to be a confidential, private investigation process if it escalates before anything might become public, from an expulsion or referral to a government agency. So, this example is just another one of the examples. They're looking for 4 people to work at a welcome table at a conference. The conference is expecting about 1,000 attendees, and they'll need 4 people to work at the check-in desk. And they provide swag bags to all attendees in the conference outlined. The company's promoting ocean fishing and the theme of geography and ocean currents. So they've got equipment and safety equipment, environmental impacts, and they want the table greeters to wear a uniform with a blouse and a black shirt. So of course we need to say to the people, of course we're going to change the words of blouse and black skirt to white top and black bottoms. And we can't require a person to wear a skirt, and we can't imply that there will only hire female people. Or Mr. Customer, you understand the reasons for that? Or are you in agreement with that? They say yes, we change the criteria and we move on. Normally we would do a roll call there. Okay, so in part 1, there's things that we can do. We can audit internal documents and practice to make sure that they abide by the Code of Ethics and Standards. We can review our service agreements with our customers and with our suppliers, and ensure that the documents and employment agreements and all of our internal written procedures and practices are all in adherence with the code of ethics and standards and the principles that they intend to uphold. We can create templates for things like job postings and other things, so that we don't have people making things up on the fly and inadvertently and unintentionally creating problems that are implied through just mistakes and lack of intention. We can provide thorough training to all of our employees to ensure their awareness of our legal and professional expectations. I mean, I think once a year at something, every company should pull out the Code of Ethics and Standards and go through the 11 principles with all of their employees at a minimum. That sounds like a pretty reasonable things to do. Owners and managers and people on the desk and people representing our companies can promote a culture that influences the treatment of all candidates' employees without prejudice. And we can create a code of ethics and operating guidelines inside our own company that ensure awareness and adherence to those that go beyond, that are maybe more specific, that drill down to the details of your company and how you handle specific things. So you can take the Code of Ethics and Standards and write your own code that at least adheres to the minimum from ACSESS and goes into further detail in your own company. And of course, we can post the Code of Ethics and Standards inside our company. So after the break, we're going to talk about some things that are called business practices and operating guidelines. And Willie will also talk about some aspects of managing your business. So it is now, I've gone overboard, 2:38. So at 2:50, 12 minutes from now, we will return back here. I encourage you to leave your screens on. Just put your mute on your button. Don't try to leave and come back. Sometimes you get disconnected and we don't let you back in the room because we're not always able to monitor that. I will see you back at 2:50 and we will go through business practices and operating guidelines. In the meantime, I will freeze my screen and I'll see you in 13 minutes. I just want to make sure that our share screen is on. So can somebody just verify for me that they've got an airplane on the screen right now? Oh, here we go. Ugh. Sorry about that. Okay, I think we should be back on track. So operating guidelines and procedures within our industry are pretty important because there's some standard things that continually come up that repeat themselves. And knowing what the industry has set for a standard, what is expected of you and other companies is pretty darn important. So we're going to talk a little bit about a thing called workforce transfer. We're going to talk about providing services, temporary services during a labor dispute when there's a strike, determining the right of referral for a placement. That's when two or more agencies attempt to place the same candidate in the same customer, headhunting for staffing professionals, the Competitions Act, we've already talked about that, assignment completion dates, hazardous material in the workplace, employer of record, and discriminatory order responses. A lot of these things we've discussed in detail. So we'll move through some of them pretty quickly, and we'll spend our time on some of the new concepts like workforce transfer. And again, we'll talk a little bit about things like workers, about application forms. Okay, so workforce transfer. A workforce, you have the sole, you've been the sole supplier to a company, to your customer, which is a provincial chain, and now they're looking to expand across the rest of the country. So they've chosen another company, presumably through some type of tender process or evaluation process, to be what they refer to as their master vendor of their recruitment programs. Now, I'm not going to go into the definitions of a master vendor, and all the ins and outs of that. That's another whole day. But you know, a master vendor is the primary supplier, and the master vendor usually is either given first choice, first chance at filling a job, or their job is to manage candidates that come from their own company and through other staffing suppliers. So everything goes through the master vendor and they monitor and manage the process. Your company is invited to respond to the RFP process to be one of the top 3 vendors in the program. And you do not win a spot. So in this case, they selected a master vendor. The master vendor is going to get sub-suppliers. You tried to be a sub-supplier and you did not win a spot. You've been asked to work with the MSP, the master service provider, to conduct a workforce transfer of your existing temporary employees. So you got a bunch of temporary employees who are currently working there on assignments, and you're not happy with the outcome, as you've had over 60 temporary employees working with this client for almost a year. You work hard to recruit and assign these employees, so you immediately get on the phone with them and inform them that you no longer have the business with Dusty Donuts. Well, I thought it was Thompson Tires. Okay, so it's your customer. And in a week's time, we'll place them in another customer's location. So thinking about the ACSESS principles and guidelines of transitioning assignments, how would you rewrite this? Well, first off, we got to get our customer straight. It's Thompson Tires or Dusty Donuts. But the other thing is, we got to remember that employees, workers, have the right to choose their employer. And secondly, we do not interfere with an employee's right to choose. And then finally, we've got some other principles like providing full and honest information to our candidates. We've got some obligations to protect confidential information. We've got some obligations to not recruit people before the end of their assignment. So if we've been given 2 months notice for the workforce transfer, placing them in a week from now somewhere else is a violation of that. We would be recruiting them early. And so let me go back to workforce transfer page. So typically, number one, you can go to the ACSESS website. Again, I'm encouraging you, if you have not already done so, contact Jennifer, create a user, ask her for a user access to the ACSESS website, and you will get access to the member only area, and you will find guidelines on a workforce transfer. The principles of the guidelines of the workforce transfer typically are that you honor the terms of your agreement, that your customer is also expected to honor the terms of their agreement. So they need to give you the appropriate notice. You need to be open and honest and transparent with your workers. You are not obligated in any way to provide confidential information about your candidates, their social insurance numbers and application forms and resumes, so that they can transfer them over. But you might be asked to do that, and you could choose to go to your employees and say to them, hey, would you give us, in order to make this simple, do you give us the authority to provide that information? There's no problems with you whatsoever in saying to a employee at the end of the 2 months or 30 days or whatever the notice period is, we have another assignment for you, and you offer them another assignment at the end of that period. You have no right whatsoever to interfere, to threaten, reprise against the other companies, but you want to try to make your customers' life as easy as possible without violating confidential information, to not interfere with the business process that's going on, that's taking place, that you are a third party or two or aware of. That would be referred to as tortious interference. And furthermore, the company that's coming in that wins the contract has got no right to receive confidential information from the client or from you about those temporary workers. So typically a client would inform the workers saying, hey, our contract with your company is over in 30 days from now or 60 days from now. Between now and then, you need to make a decision as to whether or not you wish to apply with the new company to see if they'll hire you and replace you here, or whether or not you would like to find another job on your own, or another job or assignment through your employer, but openness and honesty and transparency without the improper use of confidential information by all parties is important. Okay. Bonafide referral of a candidate to a customer employee. When a staffing firm confirms via so what they're asking is, if you've sent a resume on a permanent placement on for search or placement, when you've sent a resume or introduced a candidate to the customer, when is it actually a bona fide referral? When can you say that referral is mine and I'm expecting to receive a fee and I'm entitled to receive a fee if the person is hired? So in this little poll, the first one is, when a staffing service confirms via email or telephone that they're going to be sending a candidate over to them within the next 48 hours. So telling a customer that you're going to present a candidate and telling them their name is not considered a bona fide referral. The customer agrees to accept the introduction of the candidate or the candidates and their resumes from the staffing service. So you've said to them, hey, I've got some resumes, and they say, great, send them over. Then once the customer has agreed to receive those resumes, that would be considered an important step in a bona fide referral. The staffing service informs the candidate of the name and location of the employer, including the name of the individual to whom which the candidate will report to for an interview. That would be considered to be an important step in the process, but until the referral is actually made and the customer acknowledges receipt of it, it's not considered a bona fide referral yet. So just telling your candidate that you intend to represent them there is not enough yet, but it's an important part of the process to get authorization to submit. Number D, when the customer is informed of the candidate's name, qualifications, or a resume has been sent to the employer and evidence of the timing of receipt has been established. Well, that's good. That's an important step in the process. The customer receives the candidate's name and qualifications and the resume, and they've been submitted to the employer, and there's evidence that it's been submitted and they've received it. And the answer to the question is all of the above are a part of the process, but not until all of the above are complete. Who is entitled to a fee when two separate staffing services submit a candidate to the same employer for the same job, the same day, within the same hour? In other words, the representations of the bona fide referral are substantially similar. Where would you go to find the answer to this question? Well, I've already told you that. You can go using your member login. You can go to the members only area and you can find a couple pages specifically talking about what a bona fide referral means. How can you as a recruiter or staffing coordinator prevent the sticky situation like these from occurring in the future? Well, there's a couple things. Number one, do you have a terms of service or a contract for the job order to do placement services with the client? So just submitting a resume and not having the customer saying, yeah, let's sign a service agreement for this placement that talks about the guarantees and the placement process and bona fide referrals and what the fee calculation is going to be and the guarantee periods terms are going to be. If all of that is not in the signed agreement, it's pretty hard for you to establish what a bona fide referral is. When you do have a contract, do you actually have a job order? Is it in writing? If they gave it to you verbally, did you respond back to the customer saying, thank you very much for the opportunity to work on this bona fide position inside your company? Here's what we understand the job description to be. This is the process we're going to follow. We'll be submitting resumes to you. And when we submit that resume to you, then the date of the send will constitute a bona fide referral. Do you have anything like that at all? So often we attribute this lack of confidence by particularly by new recruiters and new salespeople, that as soon as they get the wind of an order, they go, "Ooh, great, thank you very much, goodbye." and off they go. And they're afraid that they might have to negotiate, or they might have to put something in writing, or it might be taken away from them, or the customer may not agree to a specific term. And so the easy path is to not talk about it, to just get a darn good candidate in front of the customer and hope that the merits of the candidate's credibility is going to carry you to the finish line in an invoice. This is not the way to deal with search and placement in the recruitment and staffing services industry. So the specific guidelines, again, online will tell you. So here's scenario number 2. Your customer, a contact center, is a national contact center and has 40 temporary employees working at their primary city location. You've received 3 calls this week from your temporary employees that are very concerned, and they're angry, asking why they did not get a gift card at the holiday party that occurred last week that your customer hosted. So they had a company, say, Christmas party, and they gave out gift cards to all their employees and gave none to the temps. You're receiving a call from a hiring manager. You also received a call from a hiring manager asking you to deal with the employees because they're disgruntled, and ask them to stop bothering the customer about perks that they are not entitled to. So there's a couple things. You didn't know anything about the party. That's a problem. You have not spoken with the hiring manager for about 8 weeks. So you've got this relationship, this co-employment relationship, where the people are working there as your employees, but they're working under the direction, control, and supervision of the supervisor, and you haven't checked in for 8 weeks about what's going on. Otherwise, you might have found out about the party. You might have been asked to attend. You might have been asked to bring gift cards. You might have been asked to represent your company there also. You assume that all is going well because you haven't heard otherwise. So that whole thing about no news is good news is actually not a very good principle to follow in the staffing industry when you're the employer and somebody else is providing the direction, control, and supervision. So the Call Me Center has been your customer for 18 months. So you've got this fairly minimum length to long-term relationship. And so it's starting to look like, your employees might think incorrectly that they are employees of the call center. And so what could you have done? Well, you could have been in more regular contact with your employees. You could have been in more regular contact with your customer. You could have had a written policy in place about what happens with respect to employer-employer relationships, and about company Christmas parties, and about perks and benefits and so on. So as we talk about the employer of record, we look at certain standards, and we talked about this before, but we look at things like, besides the fact in Ontario it's written into the law, and besides the fact in other provinces it's common law, but they do look at these things. They say, who is providing site-specific safety training? Who is determining what the pay rates are going to be? Coaching and counseling the employees when they're on the job? Who is managing the workers' compensation for the employees? Who's paying the premiums for the workers' compensation? Who's administering the general safety training? Who's providing the employee perks? Who supervises the employees at the work site? Who determines the length of the assignment? Who has the right to hire and fire? These are all questions, and other questions. Who's providing tools and equipment? Is there a risk of economic loss? There's all kinds of questions that are asked in determining who the employer and who the employee is, and to which employer. And so it's important, as you establish a relationship with your customer, you get as much of this in writing as possible. You act out in a regular and consistent way that supports the principles of you being the employer of record by providing some supervision, by providing guidance with respect to tools and equipment, to providing some coaching and counseling, to setting your own pay rates if possible, to participating in safety training. So at least the high-level safety training is provided by you, and maybe the site-specific training is provided by them. So in this scenario, it's expected that the staffing service firm, if retaining temporary orders, remit appropriate source deductions. If you're supplying independent contractors in temporary employees' roles to have cost savings, you may end up having a short-term gain, but be liable in the long run if you're not complying with the law. So again, in Ontario, we specifically define employees of a staffing service firm to be the employer of record of the staffing firm. And in other provinces, they use common law for that, and almost always they're found to be in that case. In some cases, with respect to unions and safety, they have what's referred to as a co-employer or a tripartite employer relationship, where two employers share in the responsibilities and can be found liable. So for example, if an employee is injured at your customer's workplace, it's going to go on your injury record and on your workers' compensation claims because they're your employee. But then if they found that there was a violation of the workplace health and safety laws, which is the other side of employment safety, not just the premiums and insurance, but workplace health and safety laws, for example, not having a guard on a saw or not training people properly and supervising people properly, it's very likely that the Ministry of Labor in your province will find both the staffing firm and the company to be liable for the injuries that occurred, and possibly fines and other compliance terms may be required. So being the employer of record is important because you've got obligations not only for premiums under workers' compensation, employers' health tax, and other taxes, but it also puts you very clearly in a position where you can take responsibility and assume responsibility, opposed to assuming somebody else will and putting people's lives and health and safety at risk. And by the way, if you don't pay the premiums and 2 or 3 or 5 years later, you're found to be that you were the employer of record and that they were not contractors, then you could have a huge retroactive amount of money that will be owed, plus penalties, plus interest. And so the short-term gain makes it look like you're earning a profit or won a customer because you cut prices. The long-term pain could be imminent. Now, keep in mind that in most provinces, in particular Ontario, and again, I don't mean to emphasize Ontario, except for a lot of these things are written already in decisions in Ontario, and other provinces look to those standards. There are other parts of the law where we went over some of these that are in other provinces and they find a way to Ontario. But with respect to independent contractors for information technology, engineering, and professionals like doctors, accountants, and architects, it is far easier to establish those types of workers as independent contractors, even if they're sole proprietors. They don't necessarily always automatically become the employee of the temporary service firm, but everything else, every other kind of job you can imagine, would fall under the default to be the employee of the temporary health company. So you got to understand your company's position on supplying temporary employees versus independent contractors, know what your company's policy is, know what your agreements say, know what the laws are, and ensure that you make sure that each of your job orders are properly classified. The federal government has cracked down on employees having independent contractor status for the withholding of taxes, Canada Pension Plan, and unemployment insurance. This is an ongoing issue. And so just, beware, make sure you know what you're doing. So managing your business. We want to prevent the consequences, which I just talked about, some of them, from handling things inappropriately. That also means managing your client's behavior. If your client is attempting to fly through the loopholes or create loopholes, you need to also manage your candidates' behaviors, because they may be trying to fly through the loopholes. And of course, reporting internally for your own business metrics and standards and reporting to the appropriate government bodies is important. You can go to the members only section and you can find many of these guidelines already well written for your benefit, but they're only in the members only area. So again, please contact Jennifer to get your membership set up. You only need to be an employee of a member company in order to get access to the members only area. Not adhering to access guidelines could result in one of the following outcomes: loss of credibility within the industry with clients and candidates. Yes, of course. Liability resulting in thousands of dollars in damages. Yes, I gave an example of what could happen if they go back 3 or 5 years and reassess you for health tax, workers' compensation, unemployment insurance, or Canada pension plan. You tend to not be found liable for the inappropriateness of not withholding on taxes. If there's a dispute over independent contractors, they'll tend to go after the person because it's their taxes that need to be paid. You could be fined for not handling it properly, even though they may end up paying their taxes. Loss of business ownership, loss of clients, loss of talent. These things are all implications and ramifications of failing to adhere to the standards. Injury that could result in death. It's happened. It's happened here. It's happened in my own neighborhood. We've had a situation not too years ago where a temporary worker were being transported to work in a company van. They crossed a level crossing and were hit by a train. Again, the company failed to have policies in place, insurance in place, all kinds of things from a company standpoint. So here's an interesting case with Denny's restaurant. In this first class action lawsuit, a class action lawsuit. This is a first class action lawsuit. A class action lawsuit is when many people with the same circumstances represented together, and the findings are for the benefit of all the people, which they call in the class. So this class action lawsuit in Canada under temporary foreign worker program, and again, this is a temporary agency or an agency operating with temporary foreign workers have got lots of other very specific laws under the temporary foreign workers program in Canada that they need to adhere to. And the lawyers of Koski, Glavin, Gordon succeeded in getting a class action certification, and the settlement was worth $1.4 million on behalf of the temporary workers for Denny's restaurant. So what happened there? So this lawsuit was the first class action suit with respect to temporary foreign workers. There were 70 temporary workers that were working at Denny's restaurants in British Columbia, and they settled for over $1.4 million. The workers alleged that they were paid, that they had paid thousands of dollars in recruitment fees. Remember, recruitment fees in Canada, in every province, are against the law. Denny's failed to provide the amount of promised work, so they came here on a temporary foreign worker program under a labor market opinion, an LMO, and Denny's would have had to say how much work they were going to get and whether there was overtime and what the payment amount was. So they alleged that there was a breach of contract and fiduciary duty and unjust enrichment, that the agency and Denny's both made extra money because they failed to pay the number of hours they were supposed to have. They failed to pay overtime hours and to reimburse them for their travel expenses. Also, workers maintained that Denny's was trying to intimidate them for participating in the lawsuit. So as soon as Denny's found out about it, they started to threaten the workers in some way, and they were found liable for that. This led to a court order that there would be repercussions because of their participation in the action. So there'd be no more repercussions against the workers because of their participation in the class action. Approximately 1/4 of the employees opted out of the lawsuit. Raised the question whether or not they did so out of fear of retribution or reprisal or repercussions. So what happened was they had 70 workers go in. Denny's apparently got upset about it, and they threatened some form or implied there would be some sort of negative repercussions. So 1/4 of them said, okay, I want to take my name away. And the courts noted that these workers were particularly vulnerable, and it was highly likely that they all opted out because of these threats of repercussion. And so whether they chose to opt out or not, they would be included in the settlement and would reap the benefits of a settlement anyways. So Denny's promised 37 to 40 hours per week. And so they were forced to pay any shortfall in the hours that they didn't work. Plus they were required to pay all of the overtime. They were forced to reimburse each of the employees for their airfare to Canada. They were forced to reimburse the fees that were paid to agencies by the employees. And Denny's, as part of the settlement, agreed to make a substantial donation to a migrant workers organization. So, you know, there are repercussions to the actions that we take. And so engaging with a customer knowingly to violate the laws and the principles that are set forth in the Code of Ethics and Standards can be substantial. In this particular case, $1.4 million to the customer. So customers can participate, can be the problem. They can discriminate. They can offer you job descriptions that are discriminatory. They can breach confidentiality. They can start making these like reference checks to their friends on temps that are there and breaching their confidentiality. They could, in a workforce transfer, could provide the information, the contact information and the names of the temps to the new company who's won the contract. They could provide you with false or misleading information about the jobs, the rates, the pay. They could not pay their fees to you. They could knowingly participate in multiple exclusive contracts. They could tell you, only you have this job order and you have the right to referral. And they could tell me that I have this as an exclusive contract. And then we could have both of us submitting the same candidates, and we could be working our buns off thinking that we had exclusives on it and didn't, in fact, and we were competing against other companies. Managing our candidates if they were their own employees. So they could be confusing the situation with respect to the employer of record. They could request screening that was inappropriate. They could request for things like credit checks and background criminal checks on candidates that have nothing to do with the bona fide occupational requirements for the job. They could be communicating with candidates or employees about a workforce transfer in advance to them going out to tender. So they could be saying, hey, we're going to go to tender, but we want ABC company to win this. Would you be willing to go over there? Can I tell them so that they will know how much to price it at? Because if they know you're going to come over, they'll price it lower because they don't have to do any recruiting. These are all inappropriate behaviors, and you know more. So it's your job to be prepared to work with your customers in your contracts, in your relationships, in your regular communication. You can research your customers' websites and their safety records, and you can review their job descriptions and their expectations. You can document all of the things that you find. You can have your own set of code of ethics and standards and procedures written in your own company. You can provide people with the ACSESS code of ethics and standards if you think that they don't know the answers or the questions or might be traveling on the wrong path. You can continually communicate and make sure that there's clarity to your employees and to your customers and internally with respect to the employer of record status. And so, you know, we need to make sure that we choose not to work with clients on discriminatory orders. We need to not use personal information inappropriately, illegally, in using it for a manner for which it was not intended to be used. We can make sure that we show concern for health and safety in the workplace and try to figure out, by doing our due diligence, who is responsible for performing work site inspections and dealing with some of the safety issues before we choose to send our workers to a work site. We can make sure that we know that all of our employees who are servicing a customer, recruiters, consultants, accounting, that we all understand what the terms of the contract are so that we don't unintentionally or intentionally breach our clients' terms. Same with those confidentiality agreements. Misrepresenting candidates to our clients So we talked earlier about honest representation with respect to their backgrounds, their skills, their experience, and their performance and reference checks. We talked about not recruiting anti-rating clauses, respecting our clients, and not recruiting the people we've placed there, or using the knowledge that we gain through developing relationships of trust and confidence with our customers who are relying upon us to understand who their employees are, what their culture is, what their pay rates are, what their job descriptions are, that we will not use that confidential information that is given to us so that it could be of benefit to them, so that we could use that information in a fiduciary manner to act on their behalf for their benefit, to provide a good, high-quality service to them, that we will not use that information in a manner to provide unfair, unethical benefit to us by using that information to recruit employees out of our client's work site. Restricting the candidates to make the choice. So we talked about freedom, that when it comes down to it, at the end of the day, candidates have the right to choose if they're given a job offer or they wish to apply for a job that's available in the public domain. It is their right to do so. Recruiting from customers or using memberships. So we talked about using our ACSESS membership to gain access, to gain information about our competitors' employees, and unfairly using that relationship and benefits to our own unfair advantage. Deriving added income through candidate fees. We understand there is no fees to candidates whatsoever. Being deceitful with candidates and clients. Of course, we're not going to lie. Whoops. Stealing away other candidates in temporary place. So we talked about enticing or recruiting or coercing people to leave their temporary assignments before their natural completion. So it's okay for people to apply for jobs. It's okay for people to give notice. But if we knowingly go in there and say, leave that job early and come to mine, like fill your own jobs, try to time it so that when they finish that assignment, they come work for you. If they're on a long-term assignment, they tell you I'm leaving soon and they apply to you, that's a different thing, but do not coerce or entice people to leave early. Inattentive, poor treatment of candidates. That goes down to the haven't talked to them for 8 weeks, didn't even know there was going to be a company Christmas party. Everybody got a company card except for our temporary workers. Pay attention to their needs, wants, desires, fears, holes, guilts, wants, pay, treatment. Aggressive tactics with candidates and clients. We talked about this before. When we are working aggressively towards people and threatening them, these are often in violation of something. They've often had a right to ask questions about and inquire about whether or not they're being paid properly or on time or treated fairly. And it is called a reprisal, and it is treated with the heaviest hand by courts and judges and in settlements when people are found to have reprised against their employees for sticking up for their own rights. I think we already went through that screen. Okay, your employee is working with your customer on a 6-month assignment. A week before the assignment ends, the employee applies to an internal job opportunity, and you hear about this when the client calls you to say that our employee went through a background channels to get in front of the customer and they're being hired. Is this acceptable behavior as your candidate only has a few days left on their assignment? Probably, yeah, it's probably okay. I mean, you want to say to your candidates, hey, look, if you're working there and you get access to internal job postings that you wouldn't have had access to out in the public domain, and you want to apply for a job there, we've got a contract with the client to supply them with people. Tell us what your intentions are. Talk to us about what you want to do. We would like to participate in your best interest. Sometimes when you go behind people's backs or apply for things, it doesn't work out so well because they don't know how to interpret that. So if you think that there's a change in job or job you want to apply for, be honest with us. We'll be honest with you. We can all be honest with the client. We can work together to try to find common ground to work in your best interest. But the answer is that this person's assignment was going to end in a week from now. So what's the real damage? And it's probably, if they haven't been there for 6 months, you can probably go to the client and say, hey, our contract says that this won't happen. You won't do this, or you'll pay us a fee, but we're perfectly willing to waive the fee if we just wait to the end of the assignment. And 1 week from now, can we agree to set this person's start date? Congratulations, they're a great employee. Can we agree to set the start date a week from Monday, and we'll continue to have them on our payroll for 1 more week? You can go ahead and do that. That sounds perfectly fine. Every situation has its unique circumstances. The important thing is that they have the right to choose. You've got a contract with the client. The candidate has got some obligation to not use confidential information that was not available in the public domain. Everybody's got a role to play in this. So, we go through the same thing with respect to managing our employees. We want to make sure that they're honest with respect to representing their skills and credentials and experience. We want to make sure that they're honest with respect to the previous salaries that they received while they were on a job. We don't want them to tell us that they received twice as much as they used to and falsifying that information as a manner for us to negotiate some kind of higher pay for them. The use of another company. So they go to another company and do that sort of fake thing like, I got a job offer, they'll pay me this much, would you pay me? You don't really want to be involved in that kind of stuff. So having people to be open and honest with you before and express their concerns to you before it becomes a problem and before dirty, competitive tactics are, pulled out, it's probably a good practice. If they fail to follow through on their commitments, so if they make promises and, every circumstance is unique. And so you got to take that into consideration too. If they fail to circumvent, like you tell them, hey, can I have your authorization to send your resume to ABC company later on this afternoon? Tomorrow morning, I'm going to go meet with them. But in the meantime, they rush out there and apply online and try to beat you to the punch. These are kind of things that you need to talk to your candidates about to make sure that it's not really in their best interest to appear to be deceitful and acting solely in their own self-interest. Of course, false references. Which statement represents the timeline to submit a complaint to ACSESS? So you got a complaint to ACSESS about another member company, or maybe even about a customer, but ACSESS really only has the right to deal with ACSESS member companies. The complaint must be submitted in writing to ACSESS executive director. The executive director will acknowledge the receipt of the complaint and refer the complaint to the ethics committee within 7 days. Yes, it must be submitted in writing. We talked about the informal process first, then it must be submitted in writing. A complaint must be submitted in writing to your general manager or HR within 3 days of a complaint. Yeah, that has nothing to do with anything. A complaint must be resolved by your company prior to submitting to the ACSESS Ethics Committee. ACSESS is going to ask people to resolve things on their own if it's their own, but a complaint must be submitted to ACSESS to Ethics Committee no later than 30 days after the initial complaint. So a complaint must be submitted in writing, A. A complaint must be submitted in writing, A, to ACSESS. And then D, if you make a complaint to ACSESS that's not in writing, they're going to ask you to submit it. If it isn't resolved internally, they're going to ask you to submit it to them in writing. There's no specific timeline on this, but if you are aware of something in a certain amount of period by, i.e. 1 year from the date that you became aware of it, it won't be considered. If it's a year old, it won't be considered. And ACSESS is going to encourage you to make a complaint in writing within 30 days of knowing, because every day and month that goes by, it's more likely that your complaint about another company is no longer valid. If people find out that they've got a process that's not ethical or legal, then they're going to correct it. So ACSESS doesn't want to be wasting their time chasing after ghosts of things that have already been fixed. So they will never consider a complaint that's more than a year old from the last time you were aware of it. And they're going to encourage you to make a complaint within 30 days of the complaint. So a complaint must be submitted in writing to the ACSESS Executive Director with knowledge of receipt of the complaint and refer the complaint to the Ethics Committee within 7 days. So the writing must be made by you within a period of time, a reasonable period of time. But once it's in writing from you, then 7 days, the Executive Director will take to quietly and behind the scenes try to resolve it with the other company. If it's not resolved within 7 days, then it will be escalated to the National Ethics Committee. So, 1, when you're aware of a complaint, you must make it within a reasonable period of time. A complaint from the last known instance beyond a year will not be considered. They will encourage you to make the complaint in writing within 30 days of the last known incident. Once the complaint is submitted in writing to ACSESS, it becomes an official complaint. The Executive Director now has 7 days to unofficially attempt to resolve it with the company that the complaint is about. If it's not resolved within 7 days, then they're obliged to escalate it to a ad hoc committee that is confidential at the national board level. Okay, so we're getting down towards the end. It's 3:35. I'm going to spend a few extra minutes for this extra throw-in. This will not be on the exam, but it's important that you are aware of this stuff. In the industry, you often hear people say, are you insured? Are you bonded? Do you have this kind of insurance? Do you have that kind of insurance? And most of the time, even people who own companies, even people who have been around the business for years don't understand insurance, nor should you really. But it's really kind of important to have an idea of what we're talking about and what people are asking about when they put it into a contract, when they put it into an indemnification clause, when they put indemnification clause into agreements, and when customers and employees ask what kind of insurance there is. So first off, commercial general liability insurance, it's called CGL. Every company should have CGL. Even if you're working out of your house making thingamahoozits, you should have CGL. Commercial general liability covers things like the Wile E. Coyote gets an anvil accidentally dropped on its head. Accidentally drops an anvil on the head of the roadrunner. So a person comes into your place of business or does business to you, and for some reason, through negligence or overlooking something or making a mistake, that person has harm caused to them. So very often it's things like slipping on the ice, tripping over a carpet, using a product that caused somebody to go blind. Having commercial general liability tends to cover against general liabilities in business. It's exactly what it says. Property insurance requires fire, including fire, water, and theft. That's for when you have an office and something happens there. It covers you if the fire is started by you and causes damage to other people and other tenants. It covers you in the damage that is caused to you in the construction of your property or the burning of your and destruction of your computers and your documents. And theft insurance is covered for when people come into your property and steal things. They break in, burglars break in and steal things from you. There's something called errors and omissions insurance, and I call this agency insurance because it doesn't cover the errors and omissions that are committed by your temps and your contractors at the customer's work site. That's a different kind of insurance. We'll call that errors and omissions contractors insurance. So errors and omissions agency insurance covers something that you did by mistake or you forgot to do that caused harm to somebody else. So let's say, for example, you had two candidates in your database named Steve Jones. One is a doctor and one is an engineer. And you accidentally read the resume of the engineer, but you're talking to the Steve Jones who's a doctor. And so you send the doctor's resume over saying he's an engineer and he knows how to build bridges, and the customer has him work on a bridge, and they design a bridge and build the bridge, and the doctor, of course, doesn't know how to build a bridge, and so the bridge falls down. This is a strange and unrealistic example. But the problem was we made an error in our identification of a person, and we omitted to go through the steps and the processes that would make sure that this resume applies to that person. And as a result of that, we unwittingly, through our error, informed the customer wrong, and they just hired them over the internet and buy the resume and sent them the work to do at home, and the bridge fell down. So everybody gets sued. Now, if you could prove that you, in truth, accidentally thought that the doctor was really the engineer, then the insurance should cover you because you made an error and omission committed by the agency. Now, you can probably think of other errors and omissions that are more likely, more practical. I just caution you on doing that because agency errors and omissions insurance is really inexpensive, and it often doesn't cover much. So beware of the buyer of regular old errors and omissions insurance. For an agency, it typically works better for people who are providing some kind of service directly to the customer. Now, in the case of contractors, if you've got this contractor that you send to the customer site and the contractor forgets to put the security back on again and somebody hacks into their bank and steals other money, the bank is probably going to sue you because your contractor made an error in reactivating the security, or they omitted to reactivate the security, and the bank blames it on the contractor because they forgot to flip the switch when they left the building. Now, errors and omissions agency wouldn't, I call it agency. Your broker is just going to call it errors and omissions insurance because that's generally covering the company for the things the company did wrong. Now your contractor has done something wrong. If you want to have errors and omissions insurance that covers the actions or omissions of the contractor on the customer site, you need to say to your insurance broker, I want a special rider that extends our errors and omissions insurance to the actions of our contractors and employees on the customer site. So this third-party benefit to cover the customer is a special rider. It isn't typically covered under errors and omissions insurance. So typically what happens is companies that have a tender and go to contract and make you sign a contract, they don't know the difference between errors and omissions agency and errors and omissions contractors. And so they have this vague clause that their lawyer put in there that says, you need to have errors and omissions insurance of $2 million. So the agency goes out and buys standard agency insurance that costs a few $100, and they submit that certificate to their customer. Everybody thinks it's fine. And then an instance occurs where the contractor commits errors and omissions insurance, and then everybody goes, we don't have insurance to cover this. So beware of errors and omissions insurance. It's important to have it, but if your contract says that you need to have errors and omissions insurance for your contractors, you need to go to your broker and ask them for a special rider or inclusion for contractors. Directors' liability insurance is the kind of insurance that covers directors and officers in a corporation for the decisions that they might make or that they may have failed to have made with respect to the operation of the business. So if they, in the case of Steve Martin, invented some bridge that goes on your glasses that holds them up over your nose in a movie called The Jerk, everybody who bought the glasses went cross-eyed because they looked at the bridge and eventually went cross-eyed. So if the directors and officers, and so they get sued by everyone and the company goes bankrupt. If the directors and officers knowingly or ought to have known through negligence allowed that product to be sold, knowing that it would cause harm to people, then directors and officers can be sued. So I use the Steve Martin example of The Jerk, but Clublink Corporation, for example, directors and officers were sued and failed, but their directors and officers' liability insurance paid for the court case, because that's what directors and officers' liability insurance does. It not only pays if you lose, it pays in the defense. But some young people went to St. Joseph's golf course in Muskoka. After their golf game, they drank. They had their keys taken away and their services eventually cut off after they got really drunk by the bar or restaurant staff. But they were allowed to drink on the course and drink in the restaurant for a long period of time before somebody said, "Hey, are you guys driving? We're not going to serve you anymore." Somebody had an extra set of keys. They got in the car, they drove off the bridge, went into the river. Some people died. Most of them died. The families sued Clublink Corporation for negligence, and they sued the directors and officers for failing to have appropriate policies in place that would protect their sons and daughters. It turned out they did have the policies in place. It turned out that they did adhere to the policies. It turned out that the people were drinking on the golf course and that the staff couldn't monitor and manage that. And Clublink then went ahead and created all new golf course policies that were even better, more rigorous. But it was the director's liability insurance that protected the directors and officers and covered them in the court case itself. Theft and dishonesty insurance. Again, this is very similar to the errors and omissions. Most theft and dishonesty insurance will protect your company, ABC Staffing, from theft that has occurred by an employee in your office. So if your accountant steals from you, if your bookkeeper steals from you, if your receptionist, like in the leather treaty case that I talked about earlier today, steals from you, it typically will cover you when an employee steals from you. It typically doesn't cover you when your employee steals from a customer. That's what's called, in the old days, was referred to as bonding. And lots of people still say, are your employees bonded? Which means, do you have insurance that will cover the loss of a third party, the customer? You sent your employee to work at the customer site and they stole from the customer. So traditionally and typically, they'd say, are your employees bonded? Which meant, did your employees go through some kind of criminal background checks and some kind of things that the insurance company required before the insurance company would cover the behaviors of that employee while working at the customer site? So very often, if you have a caregiver come into your house to look after your grandma, you want to know that they're bonded. If you have a contractor come into your house and they're going to be having free access to come and go and do repairs and maintenance or do an addition to your house, you want to know that they're bonded, that if they stole from you, that you're covered, not that they stole from their employer. So bonding insurance typically covers the third party loss, and you need to have special insurance, especially in the staffing services industry, to have third party theft and dishonesty, or fidelity and dishonesty insurance that covers the third party loss. We don't call it bonding anymore, but the people who are expecting to be covered often say, are your employees bonded? And what that means is, yes, we have a blanket third party and dishonesty coverage for $500,000 or $50,000 or $10 million. So it now comes in the form of a blanket policy that covers all of your employees working with all of your customers, or maybe all of your, if it's a very specific policy or rider, it might be all of your employees to work at one particular customer, and you got a rider or a blanket policy for all the people at that one company. So keep in mind, just like agency, if you just go out to your insurance broker and they're not really familiar with the agency business, and you say, I want theft and dishonesty insurance, they go, sure. And they'll give you some policy that's not very expensive because it only covers losses to you if your employee, if your receptionist, bookkeeper, or employee carries the checks to the bank, steals from you. If you want third-party bonding, you really want a third-party blanket theft and dishonesty coverage. So there you go. Professional liability. So professional liability insurance can be very complicated. It usually has to do with things like, is your company accused of violating human rights? Is your company accused of firing a person unlawfully? Did your company fail to provide a safe workplace? So very often, professional liability insurance, every policy is a little bit different, but they cover you for being sued for things that typically fall into all the areas that we've been talking about for the last bunch of days. If you fail to treat a person as an employee, if you fail to have the proper insurance in place, if you fail to provide a safe workplace, if you fire a person, if you discriminate against a person, if you're involved in a class action lawsuit for like Denny's, their professional liability insurance would be required to cover those kinds of things. Special insurance for medical malpractice, caregiver abuse. There's all kinds of industries out there, like the home care industry and the provision of drivers, temporary drivers. There's all kinds of special insurance out there that have got very special riders or entire policies that are added onto the professional liability, CGL, theft and dishonesty, errors and omissions, that will cover the special needs. And you have to know your business to know if you need these special policies. And also you got to pay special attention to what your customer contracts require you to have. And you find that in two separate parts of the agreements that you have with your customers. You'll find that there's very often an insurance requirement that says you must have these insurance and you must provide a certificate that proves, proof of insurance certificate that proves you have it. But you also need to go to the other part of the contract that talks about indemnifications and liabilities, because very often the contract will say, we indemnify you and hold you harmless, and you will hold us harmless. You indemnify us. You, the agency, indemnifies and holds harmless the customer for any damages that occur from something like the misuse of copyright information or the failure to pay taxes. So you got to ask yourself, is this something that, even though it wasn't in the insurance part that said it's mandatory to have the certificate, do I want to cover myself with insurance because I'm indemnifying the customer and holding them harmless, saying no harm will come if this stuff happens, no harm will come to the customer because we are indemnifying them, we will pay. Now, of course, it's never that clear. People make allegations that something happened. People say that it's not their fault, and so they don't have to indemnify them. But having insurance for those special clauses under liabilities and indemnifications is important. There's two kinds of automobile insurance. There's three kinds really. There's automobile insurance that you and I have to drive our own car, and every person in every province of Canada is required by law to have insurance on a car that they own and operate, and that they operate. So if you're the owner of a car and it's operational, you need to have insurance on it. That's the law. That's why they ask for your insurance certificate when you get pulled over by the police. So typically, if an employee goes to work and they get in an accident at work driving their own car, their own insurance would normally cover that. But we live in a litigious society, and so their insurance company might sue your company because they were driving for work, or the person who got injured in the other car or someplace, or somebody got injured, might sue your work because they were driving for work. So now none of these other insurances that I've talked about so far cover that. And so we've got what's called non-owned automobile, which means that we have insurance on damages that will occur in vehicles that we, the company, do not own, but our employees drive. So if our employee drives a customer's vehicle, if our employee drives their own vehicle and they get into an accident and somebody's going to sue us above and beyond what would normally be covered in the direct injury under the original policy that the owner of the automobile had, then you want to have non-owned automobile coverage. And then, of course, if a company owned an automobile or a truck and they're driving it or putting temps to drive it or their own employees drive it, then they need to have specific insurance for that one. So if you have a van that drives temporary workers to work, then, and your company owns it, you need to have automobile insurance. If your employees are given a company vehicle, you need to have automobile insurance. So you've got your employees need to have insurance on the automobiles that they own. The company needs to have insurance on the automobiles and trucks that they own. Your customers need to have insurance on the automobiles that they own. And you need to have, this is where the special clause comes in. You need to have non-owned automobile insurance to cover you in the event that one of your employees is driving their car or driving somebody else's car, the customer's car or truck along the way. And then, of course, there's workers' compensation insurance, and workers' compensation insurance is not required for every classification of work in Canada. It is not required for federally regulated jobs, and it's not required for certain other types of jobs. I'm not going to go through the list. I can't even explain to you why, but the vast majority of companies in Canada and in Ontario, in each province, fall under their workers' compensation program. In Ontario, it's called the WSIB, the Workplace Safety Insurance Board. This is insurance that employers have that are based upon a percentage of their payroll, their total payroll. It's very often in categories. So if you have light industrial, you might pay one rate. Industrial, you pay another rate. That has changed in some provinces, particularly in Ontario recently, one rate. It's a blended rate. This is insurance that covers the employer from things like medical costs, loss of income, and long-term disability. So we've got medical costs. When a person is injured at work, they fill out a Form 7 when they go to the hospital or go to the doctors. They tell them it's a work injury. The doctors actually don't bill the provincial health insurance. They bill the Workers' Compensation Board. So those costs are associated to your company for medical costs, for loss of income, and for long-term disability. Then, of course, there's all kinds of administration and legal fees and lawsuits and all kinds of stuff. But what workers' compensation insurance does is it's mandatory by law. Federal legislation requires the provinces to put it in place. The provinces require companies to have it in place. Companies have it by law, and it's illegal for an employee to sue their employer for injuries occurred at work because they will be compensated under the workers' compensation insurance program. And then there's a couple terms that we're going to talk about, and then we're done. Down to the last 3 minutes. Additionally insured versus additionally named insured. So when you take an insurance policy, you are the named insured. So ABC Corporation goes out and gets commercial general liability insurance. The named insured is ABC Company. So ABC Company gets sued for something that happens, then the ABC Company is covered for how much they lose in the court case and to defend themselves in court. It doesn't pay them, insure the person who got injured. So they say, oh, it's okay, you have insurance. But what really happens is company gets sued, company lose, insurance covers the company by paying it out of the insurance policy. So the named insured is the company who bought the policy to protect themselves. Additionally named insured doesn't mean that the additionally named owns the policy and has all the rights to the policy. They have the rights to damage if they get sued for work performed by ABC company on their site. So if I get a contract with XYZ company, I supply my temp to XYZ company, my temp drops an anvil, the Wile E. Coyote, drops it on the Roadrunner's head over at the customer's site. The customer gets sued by the Roadrunner. The customer loses. Now the customer goes to their insurance company and says, okay, CGL, cover me. And then they come to us and they say, we're suing you now for the amount that we lost. And they're additionally named insured. And so there might be covered if there's found to be negligence on our part. So named insured is by customer, specifically only for the work performed at that customer. It's not the same as named insured. When you get a contract with a customer, they're going to ask you for a certificate that names them, that has them as additionally insured. I don't even like to use the word additionally named insured because it uses the word named. We want to say that they're additionally insured in a clause that goes on a certificate. Joint and several means in a contract, you say we've got joint and several liability, that means that the customer, the two parties can join together to be liable for things, or they can be several. They can be separated and have several different liabilities. So when we talk about joint responsibility, it means we join together and share responsibility. When we have several responsibility, it means we're going to separate the responsibility. And joint and several means it could be joined or it could be several, but we understand that we've got joint or several liability. There's no indemnification from any liability whatsoever. And indemnification means I got you covered. And so usually indemnifications only cover things where there is negligence or gross negligence. So somebody has to know or ought to have known that their product or service was going to cause damage to somebody. You can't just willingly, something happened and somebody got hurt. They might sue you, but they're going to have to show that there was some negligence or gross negligence, in which case, if they say you've indemnified them, then they say my insurance will cover the events that happens, that I will cover you. I got you covered is basically the layman's super simplistic view of indemnifications. Of course, lawyers will argue with me because it's far more complicated than that. And that, my friends, is our coverage for insurance. That is an extra bonus. It won't be on the exam, but what every person should know. And question for people who might still be on the line. Somebody say something so that I know that you're still on the line. Okay, we've got some chats here.
Still here, just don't have any questions.
Yeah, I'm just reading. Somebody type something here. Just want to read what the question was. Oh, no. Okay.
That was my comment from earlier telling you we couldn't see the airplane screen.
Ah, gotcha. Okay. I was trying to remember what's the context of that. But you eventually, I eventually clicked the right button. So yeah. Okay, good. Good. So guys, listen, this is like really super common sense stuff. You don't need to memorize it all, but you know, when something happens, you say, hey, do we have a policy for this? Is this something that happens often? Is this something that could happen again? Is this our fault? Could we have communicated this differently? Could we have, participated with our customer in mitigating the possibility that this happened? When you know the laws and you know the issues exist, then you can go about finding policies, practices, best practices, business practices that will help you to mitigate this stuff. It isn't good enough You only have to be around this industry for a little while to realize that what you thought was common sense and how it would be thought of every day. I can't tell you the number of times that temporary workers think that they're employees of your customer. It doesn't matter that the provincial government passed a law. It doesn't matter that it's in the newspaper every week. It doesn't matter that you've got it written in your contracts and your agreements and your policies. There are just some things that are really difficult for some people to comprehend. And because they've never been around it before, they would have no reason to ever have thought of it before. These are the core principles of ACSESS, of what we stand for, of what it means to be a successful company, about growing your company, about being successful as an individual. And so I hope that you can all take it to heart, that you all, if you didn't learn something today, it reminded you of important things today. And I want to again thank you very much for participating. And I'll apologize for going 4 minutes over schedule. Everybody have a great day. Remember, we've got a conference coming up. This is the last week for early bird, low cost registrations. It's still really affordable if you wait till next week, but why waste the money? Go online, take a look at the early bird applications, find out about it now, figure out who from your company is going to go and get her done. And I'll see you again at our next CPC session. I don't think you have any more from me unless you come back again in the fall. But if you're at the conference, I'll definitely see you there. You guys are a pleasure. Thank you very much. Have a great day.
Thanks, David.
Thank you.
Take care.